Welcome back to the Commercial Real Estate Show. I'm Michael Bull. Today our show title, Oops, I should have covered that in the lease. Hopefully you don't have those situations, but we want you to avoid them, right? Well, please welcome my next guest. This is John Neville. He's a partner with the law firm Arnall, Golden, Gregory. John, thanks for joining us.
Thanks for having me.
And let's talk about retail leases, and let's start in this segment on the landlord side and maybe touch briefly on some of the top 5 gotchas, some of the top 5 things as a landlord and a retail lease, and maybe in some cases really any lease that you'd want to watch out for. What would you say is number 1?
Number 1 is I would say just say no. And by that I mean most landlord forms are going to have a list of what that landlord is allowed to charge as a pass-through expense in managing the shopping center and managing the parking lot. And sometimes that list can be a paragraph long in the landlord lease. Sometimes that list can be 3 pages long. And tenants, if they're represented, are going to want to negotiate that paragraph as to what's in and what's out.
Right.
The problem is that the more tenants you have in a project, the harder it becomes to individually negotiate that list for each tenant.
Right.
Tracking one expense out of 50 that may or may not be included can be difficult, if not impossible.
Right.
And so as a landlord, you're setting your client up to breach its lease effectively by passing through a cost that was negotiated out between the lawyers,
right,
but property management never recorded it.
Right. You might have 18 or 118 leases in one property, right?
That's right.
If they have all different things that can be included that can be passed through or not, or different limitations and things like that, it can be very confusing for the management.
So I'm a fan of, instead of having individual negotiations of what's in and what's out, start with a reasonable list so that if there are things that you would automatically not pass through if asked, let's just take that out of our form, right, and make the list reasonable. But then stick to that list, and instead, if we need to negotiate caps to make the economics work, we can negotiate caps.
Okay.
But I would prefer not to have the individuals in and out negotiated.
Yeah, and that's a good tip, because in the practice, the managers are probably going to treat everyone the same anyway, and now you're valuing the lease. So what's number 2?
Number 2, I think, is we need to make sure that we're controlling the construction process. And I will say, as a lawyer, this is a place that I think we miss sometimes, because lawyers aren't experts in construction. But there are certain things that we need to make sure as a landlord that we're controlling. Timing of plans, timing of having work done in the space so it doesn't interfere with others. And I think also making sure we control as a landlord what is submitted, because a lot of lease forms could allow the tenant to make submittals to governmental authorities before the landlord's even fully approved what's being submitted. And that can start a dangerous process that's hard to undo.
Right, and because in retail, you may have more of the tenants doing the work and handling things than you would have in an industrial and office lease, right?
That's exactly right. It is typical in a retail lease that the tenant will have a work letter of things that they are supposed to do in that space once the space is delivered. Also in a tenant retail lease, there's contemplated work that could be done once that tenant is open, 2 or 3, 4 years down the road. And again, I think the landlord just needs to make sure that they have control over that process, approval rights over that process, and again, approval in particular before things are submitted to the government.
Right, because you mentioned it could start a train, right?
It can. I mean, and undoing it, it's hard enough sometimes to get governmental authorities to start a review. Right. Much less to go to them and say, pause, we need to resubmit because there are additional comments.
Right.
It can add delay for everyone, which is bad.
Okay. Number 3 on the retail lease for a landlord oops list.
Yeah, Michael, I think here lately, co-tenancies are becoming more and more common. Everyone was bit in 2007 and 2008 on co-tenancies, and they didn't do them for a while. And I think the market is having them come back again. The reason that's relevant is that in leases, especially bigger leases, we need to make sure that our retail tenants open. I'm okay not having ongoing continuous operations clauses, because frankly, I think if someone pays the money to open, they will stay open at least for a period of time. But a lot of these co-tenancy clauses are tied to other tenants being open. Right. Having a remedy of just that the landlord can terminate if the tenant doesn't open is insufficient. We need monetary penalties, much like you would see in a construction contract, of if the tenant doesn't open on time, it's a per diem of X, and then maybe it increases to a per diem of Y if more time goes by. But something with teeth to make that tenant get open on time.
Right. Number 4.
Well, we want to make sure that we have some predictability in our project. right? Each tenant is going to want to have some flexibility, and we may talk about that if we're talking about tenant issues. But at the same time, to have a tenant state that they want flexibility to do whatever doesn't really work for a project. And a tenant may say, well, we'll agree not to violate any other tenant's use, or we'll agree not to violate any other exclusive. That's a given. But I think we need more than that if we're a landlord. We might have a certain flavor that we want for our project. We may only want certain types of retailers.
Especially today in retail, right? Because it's more about the experience, right?
Correct.
And you got to really control what these tenants are doing, or your project could go downhill.
And one tenant that doesn't fit can start a trend of multiple tenants that do not fit in that project.
Right.
And the next thing you know, again, the landlord can lose control. Similarly, Michael, I think you need control over whether your tenant is a franchised concept or a franchisor, or whether your tenant is something that has never been franchised to begin with, because there is a difference in operations between a franchised concept and a corporate store. And if the tenant can make that change without your say-so as a landlord, that could also change the direction of your project.
Right, and also that can change the monetary value of the project, right?
Absolutely can.
Because of the credit.
Absolutely correct.
Right, okay. And number 5.
Well, let's go into the legal weeds for a minute. And this is something I think that's important for everyone to understand and spend a couple of minutes on. There's a standard clause that we refer to in a lease called an exculpation clause. And it's a fancy word, but really all it means is that the landlord's liability is limited. The landlord sometimes will have multiple assets, and sometimes they won't, depending on the structure of their financing. But in any event, we don't want to create an open-ended ticket for the tenant to be able to lay claim to assets of the landlord that aren't tied to this particular project.
Right.
If you don't do a lot of retail or even leasing in general, this type of clause to a tenant may seem offensive. But it is standard in nearly every retail lease, certainly, and in most leases we see, that the landlord is able to limit its liability just to its equity interest in that project.
Right.
And sometimes, if the landlord is aggressive and fortunate, it can even limit its liability to its equity interest in the premises being leased.
Right.
Now, what that means practically is that if the tenant were to bring a lawsuit against the landlord, the most they could possibly recover is whatever landlord's equity is, either in that shopping center or in that premises.
Right.
The language also is really clear to say that no principals, no directors, officers, employees, attorneys, brokers can be sued tied to the particular deal. And again, if there is a legal action, that claim is only against the equity in the shopping center or the premises.
Yeah, well, the shopping center seems fair if I'm a tenant, but maybe not just that space.
I think it depends on the bargaining power. I mean, if you have a project that the landlord owns without debt, maybe it's a deal where the landlord bought it with partners and all equity, then, it's all about how much money should the tenant be able to grab at when it makes a claim. Because you got to keep in mind, the landlord doesn't have an unlimited bucket to grab at the tenant either. Typically these tenant deals are structured where you have either a sole purpose entity, or if they have multiple concepts, a regional entity. And that's all the landlord can sue. They may have a guarantee, but in today's day and age, the guarantee may be limited in scope.
Yeah.
So to have the tenant be able to come after a lot for the landlord, but yet landlord can't go after a lot for the tenant, it doesn't seem equitable. So this clause sort of offsets that a little bit.
Yeah, and so next we're going to talk about the tenant side, because it's different, right? There's some things, it's a different view, that's for sure, if you're a tenant or a tenant rep. So stay this one, we'll do that. And before we go, one of the tips that you and I were talking about before we recorded this show is that if you're a landlord, make sure you're aware of all your leases in the project when you do a new lease, so you don't have a problem. If we sell a lot of shopping centers and we get in there and there's a lease violating another lease, check it. Stay with us. We're going to talk about the tenant side. I'm Michael Bull. This is the Commercial Real Estate Show. Hey there, thanks for checking out the Commercial Real Estate Show. Don't miss a video of special interest to you. Be sure to subscribe below. And if you appreciate the videos, be sure and thank our sponsors. There's a link to more information about them in the description. For more videos, podcasts, and articles, check out CREshow.com.